All rise. Court of Appeals Division 1 is now in session.
Thank you very much. Please be seated. This is the time set for oral argument in Desert Peak Homeowners Association versus the Pinnacle at Desert Peak Condominium Association. Our cause number 1CACV140502. Let's begin with introductions of counsel for the appellant.
Good morning, Your Honor. Joshua Bolin, along with Alexis Firehawk, on behalf of the appellant, Pinnacle at Desert Peak Condominium Association.
Great. Thank you. For the appellee.
Good morning, Your Honors. Troy Strabin on behalf of the appellees.
Thank you very much. Let me go through a few preliminaries. First, let me just double check about the status of one thing. We had issued an order directing for the or allowing remanding for the Superior Court to consider, and then in fact it did, enter a Rule 54C judgment, and we asked that a copy of that judgment be filed with this court. A copy has not yet been filed with the court. We're aware that the Superior Court entered it, but we have not yet received it. So if you could please check, and we decided to go forward with the argument today because we know from the Superior Court records it's been entered by the Superior Court, but we have not formally received it. So if you could please take care of that.
Absolutely.
Okay. No, that's not a problem. Sometimes these things happen. Let me advise the counsel that we have reviewed the briefs. We've read the briefs carefully. We've looked at pertinent parts of the record, and we, in fact, have met this morning and conferenced the case. So we're quite familiar with the issues that you've raised and the basic facts, which you might wish to take that into account in your argument today. Each side will have 20 minutes. If the appellant would like to reserve time for rebuttal, when you go to the lectern, if you would, let us know how much time you think you would like to have, and we'll do our best not to poach on your time so that you will actually end up with some rebuttal time. Then we are recording the proceedings today, both audio and video, and for the benefit of anyone who listens in, if you could please, when you go to the lectern, restate your name. That way the listeners may have a chance to figure out who's talking. So with that, let's go ahead and begin.
Good morning, Your Honors. Joshua Bolin on behalf of the appellant, Pinnacle at Desert Peak Condominium Association. I would like to take the opportunity to reserve 3 minutes of rebuttal time to answer any further questions after the appellee has a chance to present its argument. This case really is about a condo association's statutory right to terminate a declarant-entered contract that binds the association. It is our position that the trial court erred in finding that the association did not have a right to terminate this declarant-entered contract under ARS 33-1245. That essentially is an access and maintenance and use agreement that was entered into between the declarant for the neighboring association, CHI Incorporated, and the declarant-owned affiliate of it, DR Horton, with the neighboring other association, the condominium association, the Pinnacle at Desert Peak. And we believe it erred for 3 reasons. One, it ignored the plain language and the intent of ARS 33-1245. It also added in a notice argument into it and read something notice into the statute that kind of voided the protections of ARS 33-1245. And finally, it found that it didn't find this contract to be unconscionable, and we think that was an abuse of discretion in the court finding that this agreement is not unconscionable as to my client, the Pinnacle at Peak Condominium Association.
Counsel, assume that for purposes of argument that we agreed with you that the statute applied, or that the agreement was unconscionable. So assume we agreed with you on one of those points. What would happen then? What is your idea of what would happen to this common area?
The common area would be ran as regular 2 separate associations. Most of the time what happened here, and I think where the developer made the mistake, is that you usually have a master sub-association with a number of sub-associations, and everyone's a member of the master association. And here, these are 2 separate corporate entities that are separate associations. If this agreement goes away, the condominium has its own common area property, the Desert Peak has its own common property that it owns. They would go about owning their own property and maintaining their property as they do today. The only issue would be there's a shared track that is essentially a jogging path, that half of it is owned by the Pinnacle of Desert Peak and half of it is owned by Desert Peak. That is one strip of a pathway, and it's really just a sidewalk with some landscaping on it. At that point, there was an easement that probably could be agreed upon between the parties of the right to use that sidewalk. And there's probably an implied easement because of the way that it is designed, that each association would have its still right to use that sidewalk. The question here really is that under the use agreement, and that's what we'll call it for the sake of here today, the condominium association that has its own pool, that has its own parks, that has its own obligations, has to pay 34.8% of the entire budget of its neighboring community, without any kind of offsets or anything. And that's property that goes to a park, landscaping easements. There's one park in there that essentially has a basketball court, and they're paying for this budget. Well, they already have their own property and their neighboring property.
They do have access to that.
They do have access to, under this agreement, they do have access to that at a cost of $210,000 a year while they have their own amenities. And the reason why we get to this, the statute is important, is the statute is there essentially to do two things. And this is cited in the restatement 6.19, and it also is talked about in the Uniform Common Interest Act that was adopted, not adopted by Arizona, but that is looked to nationally. And the reason why we have this statute under the Condominium Act is to do two things. One, to protect associations from developer entering agreements that would burden the association to large use fees. In this case, we do believe that 34.8% of an entire budget for a neighboring community is a large use fee. And the other one is...
But isn't that just the percentage, the population percentage? If the condo association makes up 34 point whatever percent and they have access to the overall property, why does that turn it into an unconscionable provision?
It does break it down, and the reason why it is unconscionable is because the condominium association doesn't have any type of rights that normal community associations would have. They are not members. This tends to call it common property. You see that in the agreement, common property, common property. It is not common property. It is property owned by Desert Peak, that there's an agreement that allows Pinnacle to use it. They have to pay 100% of that fee. So the 34.8%, they have to pay 100% of that. So regardless if they have a delinquency rate of 70%.
I'm not following though. Is the overall, if it just costs, say it costs $50,000 to maintain a swimming pool,
right,
that the condo residents have access to and the other association members have access to, what's unconscionable about having just on a per resident basis a fee to maintain a swimming pool, just as an example?
Because this agreement is not limited to just the use of the common elements. It is 34.8% of the entire budget. So if they file enforcement lawsuits, their enforcement action, if they're enforcing their restrictions against owners in their community, if they have collection actions against owners in their community, if they have to pay their management company, if they have to pay for different kinds of events in their community, that is part of the 34.8% budget.
But doesn't that apply to both sides, or does it not apply to Desert Peak residents? If aren't they on the hook for a portion of the fees if they had to go after an individual unit owner in the condo complex?
They are, but those are fees that are offset to their budget. The Pinnacle at Desert Peak, the condominium association, has its own budget, has its own collection items, has its own enforcement. They don't get a defrayed cost as part of the pie, essentially. If there's a pie over here at Desert Peak, if there's some kinds of offsets, the Pinnacle at Desert Peak doesn't get any of that. They have to pay 100% of their 34.8% every month without any type of offset. So it is different, because if there is the part of the pie that goes, it does made up by the other percentage. But in this case, the 34.8% is 100% paid. Where in a sub-association, all those members would be paying the master directly, and the master would then use all the fees directly to collect against Pinnacle and whatever. Pinnacle's forced to... Yes, Your
Forgive
Honor.
me, and I'm sorry for interrupting, but this is an important point. Because a lot of your argument about unconscionability is based on essentially you're paying the freight, your client's paying the freight for 100% or for costs that have nothing to do with the property that your clients have access to. But when I look at the use agreement and look at it, it says the use fee shall be an amount equal to 34.810% of the total annual budget. But then it goes on to say costs related to the PUD common area tracks and the shared channel track. So it seems like it's more limited, and perhaps there's been some overcharging, but it seems like on its face it's much more limited.
It says the total annual budget, Your Honor. It goes into all of that. So what it has been...
Total annual budget for these specified
Related
items.
to the PUD common area tracks and the shared channel tract.
Yeah, it does say that, but what's happening now is it is being paid because the provision that says it has to be paid 34% of the total budget.
Isn't that a
being paid
different
of the total
argument?
budget.
You're overcharging us as opposed to we don't have to pay anything at all.
And I don't think it is in this case, because the use fee, when you talk about use of common area, there's really only one park to be used in this. And that is a central park that has grass and a basketball court. But the 34.8, the PUD tracks, are all the landscaping tracks throughout the entire association. So if there's a landscaping or an irrigation issue that is a half a mile away from the condominium association that a condominium owner would never have the ability to use or see or advance the fair market value of their property, they're paying for all the maintenance of all their common areas.
Desert Peak does not pay for a landscape issue that's relating only to the condominium owners.
That's correct. Yeah, the condominium owners do have to pay for their landscaping issues for all their landscaping tracks. The common area tracks for Desert Peak don't just make up the one park. The PUDs don't make up the one park. It is all the landscaping contracts throughout it. So if they have 500 trees scattered throughout the community at Desert Peak, the Pinnacle, the condominium association, pays for 34.8% of all of those trees. And they receive no benefit from the landscaping or the value that it increases from Desert Peak of all that landscaping.
Is that
and
part of a
maintenance.
common area? If what Judge Norris read refers to just common areas, why would the condo owners be responsible for paying something that really only benefits Desert Peak? That doesn't sound like a common area.
It is a common area because the PUDs here are all the common areas within Desert Peak. So every parcel of property that Desert Peak owns is part of the PUDs that they maintain. And if you look at the record from the trial court, opposing counsel had a map up and all the landscaping projects were all highlighted throughout the entire community. This isn't just the use of the shared track or the basketball court. It is literally, I think it was 30 to 40 different landscaping tracks, the beautification, the monument for Desert Peak. All of those are part of the common areas for Desert Peak.
So keeping it, for my brain, simple, what you're saying is that the unit owners of the condo association have certain rights to access some of the common areas in the homeowners association. But the PUD, the PUD common areas as a defined term, includes all of the common areas in the homeowners association.
That's absolutely correct, Your Honor.
And in that sense, then, your client is paying the costs for property, or excuse me, for the common areas that it does not have access to.
No, it has access to it, but it's access to a rocked portion of landscaping. It's not a access part. It's not a park.
Okay, it's just like a tree.
It's a tree.
Okay.
A parcel of grass, a drainage basin, anything that you could think of that's just something that may be aesthetic and actually has no use. Do they have access to it? Absolutely, but there is going to be no use for it. So this.
Let's say it's a drainage basin. Doesn't that benefit both the condo and the...
It does not, Your Honor, because the condo has its own drainage system. The condo is not in any way benefited because it is its own gated parcel. It has its own drainage system. It has its own parks. It has its own pools. It has its own systems. It in no way derives a benefit from that neighboring community.
And you're saying Desert Peak doesn't pay, the residents there don't pay any of the drainage related to the...
That's absolutely correct, Your Honor. The Pinnacle at Desert Peak, the condo association, pays for all of its own amenities.
Go
Yes,
ahead,
please, Your Honor.
No, you finish up.
No, I'm just saying so they have their own separate assessment. They have their own separate board. They have their own separate declaration. They operate as an individual entity without any kind of control or say from Desert Peak. Really, the only thing that binds the two is this agreement.
But let's say they gave a voting share, percentage voting share. Would that cure anything from your perspective?
I think it would, Your Honor. I honestly, half of this is, it kind of feels like taxation without representation.
But if they have a 30% voting block on the, is that going to change?
It would at least give them a say. Because here's a prime example of what could happen. Desert Peak could still charge for the use of this, and they can make the decision. We're not going to overseed the park. We're still going to charge for it. We're going to budget for it. But this year, we're going to decide not to overseed for it. The condominium association, who's paying 34.8% of that, has no say in how that park is upkept. If they want to remove playground equipment that the Pinnacle may like, they have no say in it. They have no say. They can't attend meetings. They have no right to vote on the board of directors. They have no right to contest the amount that the assessments are raised, the amount and how the budget is set. They have no say in anything that they do. The only right that they have under this, what I reviewed today, is to write the request records. But they don't have what a typical association would have, would be able to have a member of the Pinnacle at Desert Peak sit on that board, represent the voice, keep the budget down, say what that community likes. This community over here pays 100% of the 34.8% of that cost without any say in it, and without any offsets and without any consideration for the delinquency rates and the downturn and everything like that. And it is a substantial amount of money. I mean, we're talking $210,000 a year for a condominium complex that pays basically for the use of a park. That is an exorbitant amount of fees, and that's why when it was turned over to the homeowners board, when it transferred from declarant representation to homeowners board, they immediately said, "How? This is tough. What can we do?" And that's where the statute comes in to protect them.
On the statute, if we could shift a little bit, the use agreement or the maintenance agreement is between the CHI, the original developer declarant, and the homeowners association. And the condo association wasn't in existence when that agreement was executed, and so it's not a party. With those facts, how then do we fit those facts into the language of the statute, subsection 2, about that says any other contract or lease between the association and a declarant, or an affiliate of a declarant?
Well, Your Honor, I think it did. I mean, we wouldn't be here today if it didn't bind the association.
But it is a contract between the association, which in that reference would be the condominium association.
That is correct, Your Honor. But what that does is that would create a loophole to avoid the statute. What every developer would do, they would learn their...
Maybe they did that here.
I think they did. They were trying to. But what it basically says is before the board takes control, before the developer takes control, the association takes control, any contract entered into between the association, and there was the association considered in this. It's in the use fee agreement. It talks about this shall bind the future association. They had the right to do it. And clearly here it was the declarant for Desert Peak, CHI, and D.R. Horton, and in fact it made it for itself. I think Section 2 is exactly what we're talking about here. And if we're going to say, if this court is going to say that the protections of the statute simply go away because the association wasn't formed yet, what would happen is you'd have developers under public policy simply entering into long-term management agreements, landscaping agreements, bulk contract agreements the day before they create the association, then create the association and simply avoid all the protections of the statute. I don't think that public policy favors the protection of the statutes here, because that's what the statute's here to do, to give those protections and to make sure that the association has control over the common areas, that the developer is actually turning over control.
But this is very different than a long-term contract that benefits the developer. I mean, does the developer have any, what does the developer get out of this? This is the benefit is now to Desert Peak, presumably, that was already in existence, and the developer had an incentive to try to develop the condominium project as well. It doesn't strike me that there's a great incentive, something that needs to be corrected, that developers are somehow going to take advantage of someone if they have an incentive to sell condominiums. So
right.
why not have a provision that presumably benefits condominium owners with a cost associated to that benefit?
And I see my time is almost up, but I would like to answer that.
Let's do this. Let me ask the bailiff to add additional 2 minutes. So let's take you back up to 5 minutes and then make a corresponding increase in the appellee's time. Okay, so let's go ahead and give us a second here while we do the clock. Okay. Okay.
Your Honor, I don't know the developer's intent. I can look at it and say that probably the intent and what we think it was that they wanted to market Desert Peak more, so they had to keep the association's assessments down is to add more people into that pie. And in this case, you're not only adding more people into the pie, you're guaranteeing a revenue stream from the neighboring association that wasn't yet formed that would pay automatically 34.8% of the budget to keep their assessments down, make it more marketable, make it say, hey, you can come in here, look at all these amenities you get for $30 a month compared to what it would be if the condominium association wasn't contributing 34.8%. So that is regardless of intent. The truth is there is no control here. What we wanted to do is they should have made them a sub-association where they had the rights, where the Desert Peak had to collect it from the community. They had the rights to be on the board. They had the control. They had the protections that are afforded to everyone under the Condominium Act and under the Planned Community Act to essentially give Pinnacle at Desert Peak the right to have some say in where this money goes, and also have the right to vote, and also have the right to have some control over how that property is being ran. And
Let me ask you on another question with respect to the statute. Let's assume for the moment we agree with you. The statute applies. Then, however, my concern is the effect of 4.31 of the CC&Rs of the condo association, because 4.31 basically subjects the association to the use agreement, but more importantly, it subjects or obligates each individual unit owner to basically each person acknowledges the foregoing and accepts and consents to all applicable obligations and responsibilities under the maintenance agreement. So if we were to find that, well, okay, the maintenance agreement is voidable as against the condo association, what do we do with this statement in the condos association's own CC&Rs?
I believe it goes away, Your Honor.
How does it go away, and what's the doctrine?
Because without the use agreement, without the obligations under the use agreement, that provision basically becomes meaningless. And I'd like to reverse that into our argument is the condominium association, what if it amended that provision out? If they all got together and say, let's get rid of that provision. The use agreement still exists, that still binds the condominium association. So even by a vote of its own memberships to get out of it, it can't get out of the use agreement. It's stuck in there. The only way it can get out of the use agreement is through the consent of the other party. So even if we were to amend the documents to get rid of that provision, it wouldn't do anything because the use agreement would still bind them. If the use agreement goes away, that provision becomes null and void and unenforceable, and then therefore the Pinnacle at Desert Peak no longer has to collect this assessment.
Okay.
Thank you, Your Honor.
Wait a second. We should go up to 3 additional minutes, 23 minutes, okay? Not that you need to use all 23 minutes, but you're welcome to it, okay?
I like to talk, but I will try not
Okay.
to use 23 minutes.
No, you're welcome to it.
Okay. What I want to say up front before I address the arguments that Your Honors hit, and I'm excited to address those, is this isn't all that uncommon, practicing association law, as counsel knows as well who does this. You set it up two ways. You either set it up as a master and a sub, where everyone's the same, or you set it up like this, where you have a separate agreement. Okay? In getting into that, I want to first start off with this unconscionability argument that this somehow doesn't benefit both parties. Each party has the exact same rights to each of those tracts. Okay? And I know this property very well because I live about a mile away from it. Okay? I should have brought my map for you. This property is set up in a box. Okay? The box is the master. Condominium is the mini box inside. Okay? So all of these landscape tracts, everyone in the master association, my client, they don't use them either. But you know what? If they weren't maintained and they looked like crap, they would devalue property values. Okay? So they serve a very important function that these are maintained. They benefit everyone, and they certainly benefit the appellant here, Your Honor, because that's what you see going into their property. So to take a position that, hey, just because they're landscape tracts, there's not a basketball hoop on them, they don't benefit us. Well, the owners in our association can say the same exact thing. But the reality is they do benefit us because they have to look pretty. Okay, that's what sells property.
But do the Desert Peak owners have to pay for the landscaping that's unique to the condominium owners?
You know, any landscaping within the condominium is separate, okay? But any landscaping in the Desert Peak, obviously we pay for that, but they get to use that as well. Each association has the same exact rights to the property that we're talking about. They benefit from the same, they can use it the same, they're in the same exact position, and they pay the same amount of money. It is $50, it comes down to $50 per month per homeowner, all spread across the board. Okay, so that 38%, that's exactly how you get there. So everyone is paying the exact same to use the same parcels, to benefit from the same parcels. Everything is uniform across the board. So there is no unconscionability argument. It benefits everyone the same. And that's what happens when you buy within essentially a sub-association within a master. And this is all over.
How about the argument that there's zero representation on the board?
But there's nothing related to, I guess, how do I put this, is Your Honor, I think, specifically brought up the comment about, are you overcharging us?
I'm not sure you're recording if you're not in front of them.
I was going to get the agreement. With respect to representation, I guess I have two things on that. Let me start one different. If they have a problem with that, then don't buy into the property, because one thing for sure is they were on notice up front. Okay, this isn't taxation without representation if you want to make some sort of argument like that. Don't buy in. This was set up this was put in front of the owners before they ever purchased the property. So one is they knowingly bought into this, knowing that agreement was in place, that they had to pay $50 a month. Secondly is we're talking about maintenance, and Your Honor hit it on the head. If they have an argument that somehow there may be some sort of overcharging with respect to this 34.8%, it specifically says what that's for. It does not pay for exactly everything they're talking about. That's a whole separate argument that was never brought up, although I disagree with it. The agreement's pretty clear on what's included, and that's exactly fair to everyone. It's just maintenance of the landscape, which benefits everyone, and maintenance of the park. Everyone is in the same exact position.
How about if you have to collect, let's say a few condominium owners are late or don't pay their fee, doesn't it put a disproportionate, the condominium association is responsible for all the late fees as opposed to the entire group? Are
you reversing it? Do you mean if some of my clients didn't pay their assessments and we used some of the budget money for that and they were paying for that? Yes. Is that what you're asking to reverse?
Well, both. If your clients don't pay, aren't they paying to collect? And if the members of their association don't pay, aren't they completely on the hook?
Well, if their members don't pay, they're completely separate on that, okay? And so with respect to if our members don't pay, I don't see anywhere in the agreement there that talks about, in that section 3.8, I believe, Your Honors, a reference where it talks about specifically what portion of the budget they pay for, where it talks about collection fees or late fees. It specifically relates to charges for the maintenance of the property. That's completely different, Your Honor. And
so you're saying they would not, their association wouldn't incur any of the fees to collect?
No, exactly. They don't incur any fees, and this budget is completely separate, and none of that budget amount that we're charging for is related to the collection of those fees. It should be for maintenance of the property. And if they think that some of that money was included within there, that's a overcharging argument they can bring up. But that has nothing to do with the fact that this is an unconscionable agreement when everyone pays the exact same amount of money.
Why isn't the statute applicable here? Because the reality of what happened here is that a declarant, or rather an affiliate of the declarants, of the condo association's declarant, committed to bind the condo association to a number of obligations. So why doesn't the statute apply?
A couple reasons, Your Honor. First off, this is why it's different and why it doesn't apply. Is essentially at its core, Your Honor, this is an easement / deed restriction, whatever you want to call it, between landowners at the time. Okay, it is no different, Your Honor, than if me and you own parcels of property, okay, and we are into an easement agreement, and that you had to pay me a certain amount of money, vice versa, and then you ultimately decided to create a condo. That agreement runs with the land, so then when you decide to create a condo, now you get to get out of that use agreement that ran with the land. Same exact thing. This statute doesn't apply. This occurred before you would even get into the statute.
But generally speaking, I think under Arizona law, deed restrictions are considered a contract.
Correct.
Right.
They are, Your Honor, but two reasons. One is the contract specifically says the association must enter into it, okay, and the Pinnacle this was well before they were created, platted, incorporated, declaration was recorded. And secondly, these type of contracts that he's saying that you could get around, we've never seen this happen before because it couldn't happen, is this management contract or these vendor contracts. Okay, first of all, the association would have to be a party to that, okay? The declarant cannot bind an association it hasn't created yet, okay, for one. And for two is these are different than deed restrictions that run with the land. Okay, if the statute's in place, and I've had to use it before, if the developer, on behalf of the association, after the association's created, wants to hire John Doe Landscaping Company for 20 years, okay, before the owners can get on the board, they don't get to pick that. That's what that statute is for. It's not for deed restrictions, easements, contracts, for lack of better words, that run with the land before there's even association created that binds adjacent property owners. At its core, it's just a simple agreement between property owners before anything was created, and one property owner ultimately developed a condo that ran with the land. They had notice of it. It's very straightforward and simple.
Do the individual condominium owners have notice that they will be on the hook for the late fees if some of the other condo owners do not pay?
Late fees.
There's a penalty if the condo association doesn't pay.
Well, it's essentially, I guess, obviously they have notice of the agreement because obviously that was recorded. They have their CC&Rs were recorded, and they have the public report, and it specifically says in there to the extent that they don't pay, the condo association can be sued for that amount. So there's obviously a pooling in condo association money. So with all that together, yes, my opinion would be they have to understand that if somebody's not paying, their dues are going to go up. And
their remedy would presumably be a lien against the condo owner that has.
Yes, that's between them. It has nothing to do with our clients, Your Honor. Separate issue. And our clients have every incentive. This association has the same members, essentially. I mean, obviously, we're all similarly situated. They don't want high assessments. It's $50 a month for my clients and their clients for all this property. They would love it to go down to $30. But can that happen? I don't know how cheap it is to maintain that common area. So this idea that somehow because they don't think they have enough amenities on that property that they don't benefit.
What if it's your clients own 5-acre parcels on the property and there's only 10 of them, and then the condominium owners, which are a very small percentage of the actual property, make up a significantly greater percentage of the population? Is there an unfairness there?
I apologize, Your Honor. I don't know if I was following.
It wasn't very articulate. But let's say the overall.
Let's have a do-over, shall we?
I do that all the time.
If the Desert Peak, let's say each Desert Peak owner has a 5-acre parcel. Okay, and they benefit, and the overall development is pick a number. Sure. But the condominium owners are crammed into 5 acres. There's 500 of them. Mm-hmm. Those 500 pay the same amount, or they pay 500 times the amount of the property owner who has one 5-acre parcel. Mm-hmm. He pays $50. There's 500 people living on 5 acres here, and they pay 500 times that, even though they.
Sure, I understand what you're saying with respect to the size, but in reality, how it's looked at, and this is common for any sort of setup like this, is it's really per lot, whether that lot's considered a 5-acre lot or that lot's considered a condo. It's per owner. Each owner has the same right to use those amenities, and so that's what it's charged, per ownership, per deed. And so that's certainly common all across the board, and I understand if that was the situation here, but it's not, nor would it make a difference, in my opinion, if it was. But that's how the percentages. D.R. Horton did it exactly right. It's in the public report saying how much they would pay. These homeowners would pay to our association. It shows that number, and they're about $60, even in the public report. So it's that percentage based on the overall makeup, how many homeowners in both associations, and then how many, and then you divide the percentage, obviously, from the overall to what's in the condo, and everyone is on the same playing field. So
I'd like to go back to the statute. I'm still troubled by this. The use agreement, it's quite clear that CHI committed in advance of its creation of the condo association to create the condo association and make sure that it was subject to the use agreement. And, okay, and in that sense, it wasn't it acting on behalf of the association? Admittedly, it was to be created, but wasn't it acting on behalf of the condo association?
I don't believe so, Your Honor. I don't think you can get there because it's a separate landowner at the time. The condo hadn't even been platted, developed, public report. It is truly a separate landowner at the time doing a separate agreement between adjacent landowners. Just because it's developed into a condo later on.
I thought it had been platted in the recitals. To
I
the use
apologize. Maybe
agreement.
it had been platted, hadn't been incorporated, it hadn't been a public report or anything of the sort.
Well, it may not have been marketed, but I just want to make sure I understand, because the recitals to the use agreement say the multifamily parcel zoned R2 and designated on the Unit 3 plat as Parcel 2, defined as a condominium parcel. So I thought it existed, it had been platted, it was
Well, there was I think what it means is it was that section was a parcel that was there. I don't believe it had been platted into the condo yet, meaning it was platted on the master plat, as
Right.
that was going to be. But again, we're talking about separate landowners here, and I try to use that example. If it was both of us, separate landowners, did an easement agreement, and then you ultimately decided to buy or to develop a condo, that's binding on the land. You don't get to later come out and say, oh, well, that's a contract entered into on behalf of the association, because it wasn't at the time. It was a covenant running with the land before you were even created.
But the problem with that is you do have in the use agreement that the whole intent of the agreement is that you're going to have these condominiums, and they're going to develop this or make this condominium association, and it even references the Arizona Condominium Act. It says, at such time as CHI records a plat and the declaration, the condominium declaration for the condominium parcel pursuant to the provisions of the Arizona Condominium Act 33-1201 et al., CHI intends to form a separate association of unit owners. He was exactly, he was contemplating it. He did it with the intent that he was going to make some condominiums, have a condominium association, and have the condominium association follow these guidelines. The difference between the argument that you're making with the easement between you and Judge Norris is that neither one of you are condominiums. And so,
But she could create one, though.
she could create one, but at the time you entered into the agreement, unless there's an agreement that she's going to do that, I think it's a different situation. Here, the agreement contemplates the condominiums. It references the condominium statute. It says we're going to build condominiums, we're going to have a condominium association, and these people are going to be bound by it. I just don't see how you get from that to the fact that because they weren't officially made, that the statute doesn't apply.
Just because the agreement, I mean, I guess that's where I'm looking at the language in the statute, the intent of the statute. Just because the agreement envisioned, obviously, what's going to happen, doesn't take it to a contract that was created after the association was formed and the association was a named contracting party. I don't think you can't jump that hoop, even though it envisions it, in my opinion. You can't jump that hoop. And even if you did get over there, even if this court came to the conclusion that this statute somehow applies, they have to show that it's unconscionable. And of course it's not unconscionable. Everyone pays the same amount of money for the same exact services. So that's clearly it's not unconscionable, but I don't even think you get to the unconscionable part, which I think the court certainly can rule on here with the facts that are in the record. I don't even think you get there because, again, now you're saying that any sort of contract, because obviously easement agreements, use agreements, all those are contracts, any sort of document that is binding on the land that eventually may become a condominium or whatever would be subject to this. I think that there's ramifications for that.
This statute is based on I believe it's the Uniform laws, the Uniform Condominium
Act,
Act
yep.
of 1977. And the comments explain that the purpose of the statute is to deal with a common problem, which is the temptation on the part of the developer, while in control of the association, to enter into, on behalf of the association, long-term contracts and leases with himself or with an affiliated entity. I guess what I'm struggling here is, admittedly, the condominium association was not yet created, but the developer here, on behalf of what it was going to create, made commitments and entered into agreements and obligations binding what it was going to create, which was the condo association. And it just seems like that was the exact problem this type of statute was designed to address.
Well, Your Honor, I guess I look at it. I understand where your insight there, but I look at it a little bit different on the problems it's trying to address. Clearly, the long-term contract, where, again, the common situation, which we would see all the time.
I know, it's a sweetheart deal
Yes,
with like
exactly.
the landscaper or the someone else, and I understand that.
Correct.
Yeah.
And so, and why this is so important, the notice thing. I know they want to get away from the notice thing, which stares you in the face, okay, because they knowingly bought this. Is on those situations, or what the intent of the intent of the statute is, that notice thing doesn't come into play because the board is controlled by the developer. They can enter into any of these contracts, okay, with these sweetheart deals, okay? Owners can't do anything about it. That's the purpose of the statute. They can't do anything about it because they're not on the board, and the developer, acting as the association, can do any of these sweetheart deals they want, okay? That's why the statute came into place. This is different, besides for the reason I addressed, because they can do something about this one. This was entered into, this was a use agreement binding the property
What
that they had notice.
Well, excuse
They
me.
don't have to buy. Sorry.
You're right. No one is forcing the condo owners to buy the condos. No one is putting their feet to the checkbook and saying, well, I've mixed my body parts, but no one's putting their hands on a checkbook and saying, you have to buy that condo. So you're absolutely right about that. But the question here is this, the problem that the statute was designed to address. And, yeah, there's notice, there's the $51 statement in the public report. But again, let's deal with the statute. And it just seems like this was the precise problem. So how does then the condo association and the unit that they have bought in, how do they fix this? How do they address this then? You keep saying that they can address this, but you would go back to the point which is they didn't have to buy. Well, they bought. Mm-hmm. So how then do they address this?
How do they address it up front to change it? If they would have, how do they address it now, or how would they address it then?
No, how do they address this now?
Well, this is the problem. You can't, because one, I think it was set up just fine, but so what they're asking you to do then is, our clients, $200,000 a year, obviously $50 a homeowner for all the condos, it is costing them $200,000 a year that they can't pay for. There's laws that govern how much you can raise your assessments. This association now, because they stopped paying 2 years ago, is being burdened now with all of this cost until this case is resolved. Yet they get to use the property, they get every benefit of it, it looks nice going into their property. And so they're essentially, they're sitting over here arguing that, hey, this is unconscionable because we have to pay the same exact thing as you, but then they want us to pay the whole thing. That's the result of this, and I don't think you ever get there.
If I could take a step back, you had said you not only have to show 2, but 3, which is that it's unconscionable. And I'm not reading the statute as you have to show not only that it's a contract between the association and a declarant. It seems to me that's a separate one. If you can show that, isn't that a basis for
number
rescinding? I'm looking at
Sure.
subsection 2, and then wouldn't presumably Desert Peak have a cause of action against the individual unit owners if they agreed to something as part of their purchase? Isn't that a different?
I'd have to.
Proceeding?
Yeah, no, I understand where you're going. I have to think about the separate cause of action against the unit owners, but I do want to address number 2, because I don't think 2 ever gets applicable by the exact language in there. Okay, so number 2 is saying it has to be a contract between the Pinnacle. Okay, it has to be a contract between the Pinnacle Association and the declarant. The declarant was D.R. Horton under the documents, so it has to be a contract between those two. This contract is between Desert Peak and CHI, yes, CHI and DR Horton are together, but this contract we're a party to this contract, so you can never get under number 2 because it's not between the Pinnacle and DR Horton. So you can never use number 2. The parties are different. And so I don't think you ever can even look at number 2. But by the strict reading of the statute, we're a party to that, which takes number 2 out of the mix.
Well, okay, let's assume that number 2 is out of the mix. And so we focus on subsection 3 of the statute. I do recognize that there is an oblique reference to the $51 that the condo owners would have to pay to the homeowners association. But there's really nothing in the public report that explains, well, you're going to be paying the $51 every month as long as you own the property, and you're not going to have any say on how it's calculated and how it can be adjusted or amended. I mean, doesn't that make this unconscionable?
Just because...
Or at least there's an issue of fact. For purposes of summary judgment, is there an issue of fact that is unconscionable?
I don't believe so, Your Honor. I don't believe on the facts alleged, because they don't have a say in what the fee is. It's a specific contract that's recorded. They're on notice of it. They bought into it, and the fee's the exact same.
But should they have been told, you will be paying $51 and you will have no say? Does that create a question of fact, at least to get them back into the courtroom?
In my opinion, no, Your Honor, because that claim would be against the developer, Your Honor. That claim is not against the association. If the developer did not disclose that to them, which it was properly disclosed, that would be a claim against them. My last thing I want to say is I also think number 3, it's important to note that it says unconscionable to the unit owners at the time entered into. Again, no unit owners at that time. This was before the association was created. This was a deed restriction, an easement agreement between landowners. There was no unit owner. So if you read that statute, couldn't be unconscionable to the unit owners at the time because there was none. That's why you don't get to the statute. That's why you don't even get to the statute. Thank you.
Well,
I did use all my time, so I apologize.
Well, that's okay, and we appreciated the conversation.
Oh. Yeah. You can use my notes if you want. They're good.
A few brief points here, Your Honor. One thing I would like to say that I think you all were hitting on. The association, he says it doesn't bind the unit owners, but the unit owners, the units have liens on against their properties under the use agreement. The association can essentially vote 100% to terminate the condominium under the Condominium Act, and there would still be a lien under this use agreement against each one of those individual unit owners for this amount. This amount does not go away unless Desert Peak consents to it. It is unconscionable on its face. It was conscionable when it was entered into. And I agree, I don't think we even need to get to 3. I think 3 is another thing to consider. But 2, this is an agreement entered into between the declarant and affiliate of the declarant. Desert Peak was under control by CHI when CHI entered into this agreement with them. CHI was the declarant for Desert Peak, and it was under declarant control at the time. 2 other things that were brought up here. If they don't maintain this property, it could affect the values. Well, I live in a community association, and there are hundreds of community associations next to me. If they don't maintain their property and my community association, because we are separate community associations, have different fair market values. These are 2 separate community associations.
But if you're in the middle of a larger community, doesn't it benefit your community?
It would, but we're not. This is, I think he was misstated the facts here, that it is on the corner of the property here. It has its own entrances. It has its own gates. It has its own outside landscaping. It is a gated condominium community that maintains itself. So when you enter into this community, you enter into the Pinnacle at Desert Peak. There is no say that the outside community or the neighboring community somehow is affiliated with this unless you read the documents. Pinnacle at Desert Peak is its own standing community association.
And I apologize for going over time here, but if this contract goes away, in your view, are you probably said this already, but your position is that the individual unit owners have zero liability for any common use fees if this agreement goes away?
Yes, Your Honor. If this agreement goes away, the condominium doesn't get to use the right, doesn't get to use their park, doesn't get to use anything, and the fee goes away. Thank you very much.
Well, I'd like to thank both of you today for your briefing and your argument. We very much appreciate the engagement that you both demonstrated today. We are going to take this matter under advisement. We will issue a decision in due course. We will stand adjourned. Thank you very much.